people, which I'm excited about. I think that's a good group. The last two classes we did were on building or buying a fix and flip, either through partners or through just more traditional financing, all the different options on how to gain that kind of information. If you do partner with someone on buying a property to fix and flip or even rent it out, go back to that handout, and then you can also look at these classes on YouTube, which hopefully will be pretty helpful to you guys because you can go back to it at any time. And also the nice thing is that we should be able to have a nice library of these classes going forward for your purposes and mine, because who knows, I might forget. Okay. Screen sharing is paused. Let's see, resume. Okay, so down dirty 30, evictions during COVID-19, but you could also play this into effect in many other cases as well. So back in March, federal government, Congress passed the CARES Act, which in part had a section on evictions. Essentially, what they were saying is that there's going to be a moratorium on evictions over rent-related issues, basically non-payment of rent. But Congress cannot, or at least did not, try to institute this on all types of properties. Really, they made it specific on a certain subset of properties, but then there was a more practical thing that happened that added additional layers to this. So the CARES Act provides protection from evictions right now. I think it's expiring or expiring very quickly. August 24th, it looks like. No, that maybe, let's see, I have it in here somewhere. So the major rule that affected leasing stated there would be a 120-day moratorium on rent-related evictions. The properties affected by this would only include certain types of government-backed mortgages. However, local landlord-tenant magistrate courts, like here we have in Georgia, the main avenue for evictions in Georgia, have been closed due to COVID-19 shelter-in-place orders, effectively canceling the immediate evictions of all kinds. So even though this law was only supposed to affect the federally backed housing, it affected everybody because ultimately the courts closed, no one was getting an eviction. But again, this was supposed to also only be for rent-related issues. You were supposed to still be allowed to evict someone for other defaults under the lease. And that's something that a lot of people don't recognize in the lease, and we're going to go over that as well. So signed into act or into law March 27th, 120 days, federally backed housing. You may not be served with the eviction notice until July 25th, and the notice must give you 30 days to leave the property. So this is where we kind of describe, the basics of it. So it's covered under section 41411 of Violence Against Women Act, so these are the types of loans that were covered by it. Federally backed mortgage. So let's think about it. What is a federally backed mortgage? Insured or guaranteed by the federal government, such as FHA or VA loans. Most conventional loans are not covered by this description, this definition. But also cash deals. So if you own this cash, if you have a private lender or a conventional loan, or you're borrowing from your mortgage or from your stocks and bonds, or if you borrowed from a home equity line to own this property, you are not under this government law, this law. So during the 120-day moratorium, your landlord may not charge you late fees, penalties, or other charges for paying your rent late. It's important to note that eviction moratorium does not relieve you of your obligation to pay your rent. It merely forbids your landlord from evicting you during that period for late payment. You can see already, and you probably already know some of this stuff or have heard people that are struggling with it, but there was a lot of confusion over this. Am I covered? Am I not? Can you evict me? Can you not? And Rollo, I'll send you a link for all that stuff. Tal, if you think that it covers all of the loans, conventional too, I think that just adds to more of my confusion over this law. Ultimately, I think the real issue was that no one was getting evicted during this time, and it's still hard to get evicted during this time. So let's dig into what's more important. So I had a lot of clients reach out to me and say, what do I do? whether it's a tenant or a landlord. I'm in this bad position, the tenant's not paying rent, or I can't pay rent, whatever it may be. What are my options? Or even more so, the tenant doesn't want to move in. They sign the lease, they put the security deposit down. I don't want to move in. I never took possession. Can I get my money back? All those things are big issues that we have to address. And the way we address it is we actually read the lease. The lease is not a lot different from your promise to pay on a note, that you are promising to pay this lease unless there's some condition that allows you out of it. And there are very few. So let's just start looking at it. First, this is F913A3. Tal, I know you use your own leases, and you may, the other people in this class may have their own leases as well. So you can obviously, you have to read the lease that we're specifically talking about, or if you have questions about, but most people are going to use the SCAR lease. So tenants shall pay monthly rent of blank. There's a reason why that's the first sentence. Georgia law has developed over the years to say, as long as the tenant is paying rent, then all these other things can apply. But they do not give you any of these defenses. You are not allowed to fight for your rights, for the most part, if you're not paying rent. Georgia law is very landlord friendly in that sense. And other people, they might have an opinion that maybe Georgia is not landlord friendly, but the number one law in landlord-tenant disputes in Georgia is that you shall pay your rent. You pay your rent first, and only once you've done that do you have some of these other things at your disposal. That's the most important part. If we look number 2, rent's due by this day of the month. There's late payments. If you don't, obviously under the CARES Act, you're not allowed to charge late payments for non-payment or for being late. Let's keep going into the rent. This is 913B3. Tenant shall pay rent in advance to landlord monthly. And in advance means that you're paying at the beginning of the month for that month. If anyone could put in the chat, what's opposite of that? Is there anything that when you come to a closing, if you've been in one of my closings, you've definitely heard me talk about this, how it's the opposite of rent. That's right, Rolo, you're paying your mortgage in arrears, or you're paying your taxes in arrears. So in a mortgage, the interest would accrue all month long. Let's say, like right now, it's September 2020. So interest is going to accrue for the rest of this month, and then you pay that interest back October 1st in your mortgage. So the rent is the opposite. You're paying September rent the 1st of September, and it covers your occupation in September. So just note that it is a little different than mortgages. And you may assume that everything was working the way rent does, and it just doesn't. The mortgage, you're always paying it backwards. And that is a big reason why when you pay your last month's rent, you're still living at the property. You're still there, you've got another month left, or whatever many months you have that last payment. Whereas a mortgage, once you pay that last mortgage payment, the mortgage is paid off. It's official. It gets canceled of record, it's done. They don't make you wait any further because you just paid everything that was due in arrears plus the principal. So when we look at this, so tenant shall pay rent in advance to landlord monthly in on or before the due date during the lease term to the rent payment address, which is listed in this lease. And then let's keep going. Liquidated damages. So let's say you're not paying the rent. What happens then? And this is a big deal whenever I read a contract, and hopefully this can help you. We always want to look at, and when we're reviewing a contract, we want to look at what are your rights, what are your responsibilities, and if either of those are affected, if you're not doing what you said you were going to do, or if someone's taking something away that they were supposed to give you, well, then what? So up in the front, the lease, we're looking at the tenant has the right of possession. They're allowed to be there. That's their right. Their responsibility, they have to pay rent in the basic terms. There are other things that they have responsibility to as well. And then if they do not follow those responsibilities, or if they don't get those rights, if they're not given access to the property or things of that nature, then we look at the last part, which is what happens then? What are the issues then? So let's look at what's next highlighted, tenant agrees to cooperate with landlord and landlord's agents who may show the premises or property to prospective tenants or buyers. In the event a lockbox is installed, tenants shall secure keys and all that other stuff that could be stolen. For each occasion where the access rights described above are denied, tenant shall pay landlord the denial of access fee as liquidated damages in the amount set forth elsewhere herein. So what does that mean? This came up so often over the last 6 months where someone wanted to basically say, you're not allowed to come into the house or show it or sell it or anything of that nature because I'm afraid of COVID-19 or I need, I'm not allowing it or I have a valid lease and you're not allowed to be here. Well, this is a big deal right here. You are agreeing, if you're in the GAR lease, you're agreeing to allow the landlord to access the property, to show it, to sell it to prospective buyers or otherwise. And if you do deny it, there are liquidated damages that are owed. There are fees and fines. You could be kicked out. You could be under default, which is the next section. So F19C1, default. Tenant shall be in default of this lease upon the occurrence of any of the following. This is the big deal. This is something that not many people truly read. And I think they should, because what does it mean to be in default? We already know some of the big ones. So number one, tenant fails to abide by any of the terms and conditions of this lease. In other words, if you're not paying your rent, if you're not giving the landlord access, if you're not maintaining utilities and other things like that, which actually is later on in this. Two, tenant files a bankruptcy petition, which in this case, the lease shall be automatically terminated. Tenant shall immediately vacate the premises, leaving it in the same condition it was in the date of possession. Normal wear and tear accepted. So I'm going to ask the group, why do we care if the tenant declares bankruptcy? Why is that an immediate default and the tenant needs to vacate? What's the reasoning? Can anyone answer? And Michael, in the meantime, Michael asks or says, in reality, the terms of the lease don't matter when you get to kangaroo magistrate court. Yeah, that's a good point. You cannot always count that the magistrate court will follow or follow the rules of your lease. They can make it up on the spot, which is why judges are so important. Tal says federal bankruptcy court trumps this clause. It trumps the clause, but why is it in there, Tal? Why is it in there? Anyone? Why do we care? Because it's the same clause that's also in a note or a security deed. Why is this a big deal? I'll tell you why. It's a big deal because if you declare bankruptcy, you potentially could have this lease torn up anyways. You could have all of your debts just wiped off the face of the earth. And in the meantime, there could be, thousands of dollars of back rent or future rent that's currently going to be owed. And the landlord cannot afford to be kind of cut out after the fact. The tenant is getting some sort of benefit from this lease and they need to pay for this lease. And if they're going to declare bankruptcy, then they need to either, like what Tal is suggesting, basically set the lease aside and secure it. So the bankruptcy trustee would say, hey, no, this lease is not going to be cleared by the bankruptcy. And so landlord, you're safe, you're going to be okay. Or they need to leave. And so the landlord can find someone else that will actually pay rent. That's why it's in there. It's a big deal for a landlord who is owed money. Very, very big deal. So number three, tenant fails to pay timely rent or other amounts owed to landlord under this lease. That means not only do you have to pay your rent, but you're required to pay the late fees in a non-COVID scenario. You're absolutely required to pay late fees. And if you chose to no, I'm not paying that late fee. I'll pay you the rent. I'll pay you the rent. I'll pay you the rent. And there's maybe $100 in late fees or $1,000 in late fees. You're in default and you could be kicked out. So number four, tenant fails to reimburse landlord for any damages, repairs, and costs to the premises or property other than normal wear and tear caused by the actions, neglect, or intentional wrongdoing of tenant or members of tenant's household and their invitees, licensees, and guests. That's a big deal. We have to protect the landlord's property. The landlord is entrusting the tenant with their property and they don't want it to be wasted. That's a legal term where someone who has possession of a property or has control of it allows it to go into disrepair. That's called waste. and the courts will protect against that. Number 5, prior to the end of the lease, tenant either moves out of the premise. This is the big one, by the way. This is the one that not many people even realize exists in there. Prior to the end of the lease, tenant either moves out of the premises or shuts off any of the utilities serving the premises without the consent of the landlord. That is a big deal. And why is that a big deal? Because it goes back to one of the first questions that I brought up at the beginning of the class, which is, if you never take possession, you are in default. So if you're in default, then you're going to owe the entire lease potentially. And we'll look at that in letter B, effective default. So I think that's a really interesting point. Let's say you have a 12-month lease and you move out. You're in default. Or if 2 people are on the lease and one of the tenants moves out, let's say they were boyfriend and girlfriend, and the girlfriend moves out. Well, she's on the lease. That's a default. You could potentially put the whole lease in jeopardy. Maybe a judge would ignore that and allow that not to be a default, but you're still going to have to go through the eviction proceeding. You could really upset a landlord. And why a landlord would even care about that? Well, you just lost someone who was guaranteeing the lease payment. You went from 2 incomes to 1 potentially. And so that's a major issue for the lease. And maybe the landlord does nothing about it as long as the rent is continued to be paid, but they could. They could say, hey, by the girlfriend moving out, you're in default. And the default, let's get to letter B, effective default. If tenant defaults under any term, condition, or provision of this lease, landlord shall have the right to terminate this lease by giving notice to tenant and pursue all available remedies at law or in equity to remedy the default. All rent and other sums owed to landlord, this is called an acceleration clause, through the end of the lease term shall immediately become due and payable upon the termination of the lease due to default of tenant. Such termination shall not release tenant from any liability for any amount due under this lease. All rights and remedies available to landlord by law in this lease shall be cumulative and concurrent, notwithstanding anything to the contrary. In the event of a non-monetary default, such as moving out, that is reasonably capable of being cured, such as moving back in, landlord shall give tenant notice of the same and a 3-day opportunity to cure the default. That's a really, really interesting result of that. Basically, they're saying you agreed to pay 12 months, a 12-month lease, or a 24-month lease, or a 5-year lease. Say it's a commercial deal. You agreed to the full amount. The landlord paid the commissions to the brokers. The landlord, maybe refinanced their loan because of this new income stream. And now if you're not going to pay, or if you're going to move out, or if you're going to shut off the utilities, you're in default. You're going to cause the landlord some serious financial hardship. And the effect of that is you have to pay everything today. We don't have to wait for you to miss that next payment. We don't have to wait for you to miss the next 12 payments. You can sue for everything right now, which is crazy. I think that's amazing if you're a landlord. But it does lead to some downsides, obviously. And I'm sure you are all thinking of the downsides, depending on which side of the fence you find yourself normally. Tal has made a couple of comments in here. He represents a lot of landlords, and he probably knows, or he definitely knows, landlord, magistrate, landlord tenant law in Georgia. He knows it better than I do. But, he represents a lot of landlords. He's thinking it as a landlord or as a property manager a lot of times. You might be thinking it as a tenant. Maybe you yourself are a tenant and you're thinking, oh my gosh, like if this house isn't good, if I'm struggling, if I lose my job, or if I have to file bankruptcy, I'm going to get kicked out of my house. This is crazy. Like, or what if the landlord's not fixing the house, or this and that? Well, there are a lot of if and thens. There are a lot of defenses to an eviction that a tenant is allowed to bring up, as long as they're paying the rent. That's always going back to the rule number 1 in Georgia. If you pay your rent, then you can complain about the landlord doing this, or the failing to do that, or this happened or that happened. And so we can look at all of the totality of the circumstances as long as you pay your rent. So Denise, what if a tenant makes an unauthorized repair to the home? Well, that is not their right. They are not permitted to change the house at all. And that is in a different section of the lease. The lease is several pages, it's probably 6 or 7 pages, not dissimilar from the purchase contract. So there is a section in there for unauthorized repairs, and that is a default. You could be kicked out, basically evicted, and then the landlord could sue for the balance of the rent. So if you're halfway through a 12-month lease, you've got 6 months left, it's $1,000 a month payment. So you're going to get evicted, and you're going to owe $6,000 in future rent immediately. And you're probably going to have damages to the landlord for that unauthorized repair. And you might have other fees for the eviction and things of that nature. It can really build up. It's pretty ugly. Yes, Tal, you're right. The due on sale clause is the same thing, which is in the note or the security deed of the mortgage. And the due on sale clause has an acceleration clause. It says if, and Tal and I have talked about this actually, if you put the property into someone else's name who is not your wife, or there are a couple other exemptions like putting it into your trust, but if you put it into anyone else's name, or if you add someone else to the title, or you take someone off of the title, you could be in default of your note for the mortgage. And they could accelerate the terms of that note and say, everything has to be due now. We do not like what you're doing there. Other things would be, if you started a meth lab on the property, you're not allowed to do that. That is a violation. That's a default under the lease, and you could get evicted. So Denise, I hope that answers that question. Let's keep going. So now we have to think about, okay, something has happened, and we either need to get out of the lease, or we need to evict the tenant who will not leave or will not pay. We need to find some sort of solution so that the landlord can move on, so that the tenant can move on, whoever it is, the moving party, so that they can actually do something that helps them. And so the two examples would be the tenant's not paying rent because they lost their job, but they won't leave either. Oh God, that's, as a landlord, that's awful. It's costing you money now. You're not making money on this deal. So the other scenario is the property is no longer fit for my purposes. I'm moving out of town, or I want to buy a house. I'm sure that's actually the scenario you guys are probably seeing a lot, where you're working with someone who has a lease, and it's not just 1 or 2 months that are left, but maybe 6 months or 8 months. They just signed it back in, March or April. So in that scenario, what do we do? What are our options? How do I advise my client as to moving forward? So let's look at them. Mutually terminate the lease. Number one, if the lease is nearly up or coming up close and the tenant is planning to move in with family, facilitate that by allowing them to move out of the lease early and releasing the security deposit back to them. That is a very generous thing that a landlord would do, but it happens. It really does. So let's say it was a 12-month lease. In month 10, the tenant says, hey, I've lost my job, or I'm getting married and I'm moving in with my family. Is there any way that you would let me out of the lease early? There might be a way you would let them out of the lease early, and let's think about the options. Let's think about why. One, maybe the landlord can get more money by renting it to someone else. Two, maybe you can negotiate something where there's 2 months left, they'll pay 1 extra month, they'll get their security deposit back, and the landlord ends up 1 month better because they turn around and rent it immediately to another tenant. Maybe there was someone who was waiting for this property, and this would be perfect. There are scenarios where you let someone out of the lease and it actually benefits both parties. So mutually terminating the lease is the way to go if it's possible. If you have a landlord that has other options, if you have a tenant that needs to leave and you want to be the nice person. We are all in this business for our entire careers, hopefully. And so this is the way that we build goodwill, that we basically say, let's ask. Before tensions rise and everyone gets really angry, let's ask what's going on. Let's see where our options are. Number two is a little bit more one-sided, and this is called cash for keys. So cash or keys, it's a concept that's been widely promoted and used for many years, may have increased applicability in today's environment. The thought is if you're facing 3-month eviction process as a landlord, with major disruptions to your personal, professional objectives, such as it's costing you a ton of money and it's just annoying and you go to sleep thinking about it, it's just awful, you should consider offering just a cash settlement to get the tenant out quicker. So here's the example. I'll offer you $1,500 if you get out by next Friday, so that it will help you with the move. You can hire a moving truck. You can put a security deposit down on the new place. The upside, so let's think about it. You get rid of the tenant in a week. Get rid of a tenant who cannot pay rent while allowing yourself to find a new tenant who will. You may also be able to avoid destruction to the property and prolonged court battle and expensive attorney fees. I'm sure Tao can tell you all the ugly things that happen in this business, but basically there are tenants who, if they feel that they are being treated unfairly during an eviction process, they will destroy the property. They will steal things. They will rip stuff out. They'll leave, which is also a default under the out of the lease. So the downside, so let's think of the other side, paying a tenant who actually owes you money could offend your conscience. However, you have to consider the potential upside. So this is a thing where what the typical client says is, that's just wrong, right? That offends my principles. Okay, I agree. So let's think of the two options in that case. You have a tenant who will not leave or cannot afford to leave. So they're digging their feet in the ground. They're not doing anything. You offer them $1,500 to leave today. Done, I'm out. And they scramble for the door and they take your money. You get the keys, you give them the money, and you're done with them. You can sell the property, you can rent the property, you can rehab the property, and it costs you $1,500, and you probably had to give up $1,500 that you were owed, but you got done with them and you're allowed to move forward. The other option, you could hire an attorney. It will cost you $2,500 and it will take you 90 days. And you have, at the end of it, a judgment. So you would sue the tenant, you would, let's talk about the process for eviction. It is the landlord-tenant magistrate court in Georgia. So every county, if let's say it's Cobb County, you're going to go to the Cobb County Magistrate Court and you're going to file your eviction. You're going to say the tenant's not paying rent. Here's a copy of the lease, all that stuff. So you file a lawsuit, you pay a couple $100s in court costs, and then the tenant has 30 or 45 days to respond, to give their answer. Then you have discovery, then you have mediation, then you have your court date with the judge. 60, 90 days in a normal case. With COVID-19, it's probably 2 or 3 times that. So you're looking at 6 to 9 months, easy. And at the end of that period, when you're in front of the judge might agree with you, or they might not. It's possible they wouldn't agree with you. But let's say they do, and they approve the eviction, and they sign in a judgment on your behalf for, say, the back paid rent, say it's $5,000, which you can turn into a lien, and you can try and garnish wages or anything like that. And then you have to hire the sheriff to come out and actually physically evict the tenant. In the meantime, the tenant is not treating your property right. And you've spent thousands of dollars. Even if you did it yourself, you've spent probably $1,000. And it's really awful because you're not making money, you're missing out on tenants, and you don't know the time frame. So you can see how it can get really ugly. And if you just pay them up front, you can get rid of that. You can speed to the front of the line. It's like paying for a fast pass at Disney World. It's expensive, but I think it's worth it if you only have one good day, right? Here's the other side of it. That $5,000 judgment that you feel like you're missing out on, well, who is it against? It's against the tenant who's not able to pay their rent. That's not a judgment that I really put any value on. That money you may never see. The likelihood you ever see is probably slim to none. So you're not really giving up that much for most tenants, and the upside is that you get it faster. So I think it's a real benefit. What is the monetary cap at the eviction court? Rolo, I don't think there is. If you're evicting someone, the monetary cap doesn't permit. Small claims court, I believe, has a monetary cap of 15,000, but you're not suing in small claims court. This is magistrate court. So it's possible that they could elevate you to superior court if it is a certain really, really high number, but generally you would look at it, there's no real cap to that. And Michael, you're right, you have to wait for the marshal appointment. That's right. So Tal says, goodwill is great. And so this is, and Tal represents a lot of property, a lot of landlords. But if you represent multiple landlords, you run the danger of HUD/fair housing for making decisions differently for different people. Better to have consistent rules and apply them always. Yes, absolutely. But I do not allow concern over fair housing to rationalize you being unfair. So if it's fair to you and fair to them to let them out of the lease early, then you can allow them to let out. There's no violation there. And the fair housing violation would come from the tenant who makes a complaint to to someone else. That I would say that's not a concern of mine, but Tal, you've probably seen it. I don't doubt that you've seen that. So let's keep going. So we've talked about the mutual termination of the lease, the cash for keys. Number 3, the deduction from security deposits. And this is something that not many people even recognize as an option. So holders shall have the right to deduct from the security deposit, 1, cost of repairing any damage to the property, 2, unpaid rent, utility charges, or pet fees, 3, cleaning costs if premises is left unclean, 4, the cost to remove and dispose of personal property, and 5, late fees or their unpaid fees. I think most of those things you recognize, damage to the property, late fees, things like that. Anything you didn't pay, that's going to go to cover it. But the unpaid rent is something that not many people were probably recognizing. They would collect this $3,200 in security deposits, and then COVID-19 hit, and they're like, well, my tenant's not paying rent. My tenant's not paying rent. What do I do? What do I do? I said, well, you've got money in escrow, or you took a security deposit, so you're not necessarily, you could pay your mortgage in the meantime with that. Now, obviously, then you're depleting the security deposit, so it's increasing your potential risk. But at least you're paying yourself as a landlord. You're allowed to take the security deposit to pay your mortgage or to pay yourself in the event the tenant's not paying you. And I think that's a really interesting clause in the lease that you can always use to your benefit, and to allow a tenant some sort of wiggle room. And with the idea that they pay you back, with the idea that they build back that security deposit. And that requires a lot of goodwill. It requires, good communication, and that you trust the tenant. So that's a big deal. So number 4, negotiate a forbearance or repayment schedule. So this actually came up during the last 6 months. Landlord agrees to defer 100% of the rent for April 2020 because of COVID, and accepts 50% of the rent for May and June. The 50% rent payment was to be paid May 15th. The 50% June payment was to be paid within the time period prescribed in the lease. The deferred rent will therefore be paid in 6 equal monthly installments commencing on October 1. So this is obviously a longer lease, but it can be worked out with a year-long lease as well. So you talk to a tenant who says, hey, this is my industry, this is how I earn a living. We're going to struggle for the next 2 months, but between the large security deposit that I have with you, give me April off so I can get my wits about me. Give me a break in May, give me a break in June, and then I'll pay all of it back over the next 6 months. And I think that's very realistic. I think that's very open, it's very honest. And as soon as they don't make one of those extra payments, then it all is accelerated. And you just have that open discussion. Say, hey, look, I gave you these options. You're just not able to make the payment anymore, and we've got to terminate the lease, and I need you to leave. Otherwise, they start making those payments, and there's an actual plan. There's a plan to pay it back, because this moratorium on the rent payments, the eviction for rent payments, once it ended, that full back payment was due right then and there. So it was a way for the landlord and the tenant to stay on the same page with very reasonable expectations. So if you agree to something like this, like I negotiated with some of my clients, you put it in an amendment to the lease that says this is how the new payment schedule is. And you don't really have to describe as to what it is. You could just say, nope, here are the new payments. 0 for April, $500 for May, $500 for June, and $1,500 for every month thereafter. I hope that makes sense. And then obviously the last scenario is eviction. And we talked about the process for that. It's not fun. There are not many attorneys that want to do it because it's not a very lucrative business. And I don't do it. But what I do is I try to empower my clients to do it themselves. So I tell them how to do it, where to go, what it's going to take, and what the time frame looks like. And then if they need me, I'll review a contract for them, or I'll help them with the paperwork or something. But I can't do it myself. I don't have that time. I'm not down at the courthouse every day. So a lot of times I think you'll find you're on your own for evictions. And that in itself could scare you into making some sort of negotiation with the tenant or with the landlord, saying, I don't have the stomach to do it myself. I can't find a good attorney that'll help me. Let's just get this done. So that leads to the next big topic, which is what do you do? What do you take from this if you never do another lease in your life? Well, I think what you take from this is that you never buy a property with a tenant who says they're going to leave but hasn't actually left yet. That's the answer. So do not, assume without at least advising your client of the realities of eviction. Don't allow them to do this without the information. So you find a property that is, maybe needing of a significant repair. You're going to fix it up. You're going to, sell it or live in yourself. But there's a tenant there, and there's a long-term tenant, been there for a long time. They say they're going to leave in December. Well, it's September. I want the house now, and I'll get the rent payment in the meantime, and this and that, or whatever it is. Or they're going to leave Friday and closing's on Monday. I think you need to ensure that they're out before you spend money on the house, and that could disrupt some of your plans. But what it does do is it protects you from having to be a landlord that has to evict a tenant that you don't know. You don't know the whole backstory, that you don't know all of the negotiations, and you don't know the tenant scenario. So, don't buy a house with a tenant that's in there that you were planning on evicting. And if you were intending on buying this house with the tenant for the purposes of earning the income, do a tenant estoppel. And a tenant estoppel is basically saying you hand the tenant a letter saying, hey, fill this out. What do you know to be the terms of your lease? When do you pay your rent? When does it expire? How much is in security deposit? Is there a pet deposit? Who's on the lease? Is this a copy of the lease? And that's called an estoppel letter. They're great. And what it does is it allows you to confirm all the information that the listing agent or the landlord has provided as part of the closing documents, to say, okay, well, the landlord says that your security deposit is 0. Is that true? And the tenant says, that's not true. I put $1,500 down. Here's a copy of the check. That's a big deal. So definitely always talk to the tenant before you buy something. If you don't want the tenant in there, don't buy it until they're gone. And if you find yourself where you have a tenant that you need to evict, go to them directly, make them an offer that gets them out sooner. And if they're not reasonable, if they don't like any of the options you give them, then you have to evict them. You cannot forcefully remove them from the property yourself. You can't change the locks. You can't do any of that stuff if they're currently living in the house. So that leads to the last question. Can anyone answer this question? What if the tenant leaves? They remove out all of their furniture, and there's maybe a couple of things, and they didn't tell you, and you find out, and there's 6 months left on the lease. We found out earlier, if we scroll back up, that that's a default under the lease, right down here. So prior to the end of the lease, tenant either moves out of the premises or shuts off any of the utilities. And the defective default is that you can kick them out, right? And you can sue them for any remedies under the law. Do you still have to dispossess them? Michael says yes. Eugene says yes. Baraba says yes. Tao, what do you say? What is dispossessory? That's the real question. Dispossessory is kicking them out. It's physically removing them. It's evicting them. All you have to do is change the locks. You take possession, you change the locks, and you can rent it to somebody else. They've already left. They're gone. So not required. You're right, Tal. Grounds for disposition action, but it's not required because they're already gone. The only reason you go through the eviction, I suppose there are two reasons you would go through it, the dispossessory, is that you would get them out and you would get a judgment. We can get the judgment later. You can go through small claims court, you go through magistrate court, you go through superior court probably, but you're not suing for eviction anymore. You're just suing for a judgment on the back paid rent or future rent that's now due and payable. So I think that's an interesting concept. If you can get them to move out, or if you show up to the property and all their stuff is gone, you change the locks and you terminate the lease, or terminate the lease, then you change the locks. You know, and I think the one other piece of this is that if we look on the last line of the effective default, right down at the bottom here, landlord shall give tenant notice of the same and a 3-day opportunity to cure the default. And that's in the event they are default for something other than not paying rent. So you probably have to terminate them first. You give them notice saying, hey, I went by the property. You're not there. All your stuff is gone. That's a default under the lease. You know, please let me know what's going on. And if they ghost you, if they never respond to you, or if they try and like drag their feet and they never actually move back in, 3 days later, you have the right to terminate the lease in earnest, and you can change the locks and take possession. So I hope that's helpful. Michael says, I have had a judge award a tenant $5,000 because I changed the locks after they moved out. That's scary. That's freaky. I don't know the specifics of that scenario, but legally that's not supposed to be what happens. Could have been that there was other issues. It could have been, there's another thing called constructive eviction. I don't know if that was the case in this one, but constructive eviction is where a tenant says, hey, the property was so bad, or the landlord was such a nuisance or harassing or whatever it is, that you've constructively evicted the tenant, even if you didn't specifically ask them to or make them leave. So a constructive eviction could say, no, now the tenant has been derived of its rights or deprived of its rights to possess this property, and due to your actions or inactions, the tenant is actually going to be allowed to leave and have damages against the landlord. I don't know if that was the case. It sounds like it was pretty ugly though. I don't like that. So Michael, as a follow-up, they told me they moved out but left their stuff and went back to get their stuff and locks were changed. I think stuff, that's an interesting thing. Obviously, you got to have good evidence. If you had a video when you walked in and there's a bunch of feces on the floor and a beat up old couch, I don't think that's stuff. But if all their furniture is still in there and they're physically not there, that's probably not good enough. And you have to give them that notice of the default and ability to cure. So, if you walked in and you're like, oh my gosh, all the stuff is gone, you reach out to the tenant, like I said, and they never respond or they never come to pick it up, I don't see how you could lose in a case like that. But Michael said earlier that it is a kangaroo court, so it's not entirely predictable. Tal says, as a final summation of this, that's why abandonment can be a gray area. It may make sense to file a dispo. Utilities turned off is a good indicator of abandonment. I think that's right. It's a totality of the circumstances. And again, do not miss that ability to cure the default. It's not a whole lot different than some of our other contracts with the purchase and sale, that if the tenants and if the buyer is in the default, say they didn't submit the earnest money, or maybe they've been slow to apply for the loan. The conventional loan contingency says that you got to be proactive, you got to be vigilant and quick about applying for the loan. But you're slow, you're taking a week or 10 days. Seller can't just terminate you. They got to say, hey, I'm giving you notice, this is not acceptable, fix it, let's go. And if they don't respond, if they still are slow, then it's grounds for a default possibly. So keep that in mind. You always want to make sure that when you get in front of a judge, you look like the victim, always. And that's always going to be my advice to a landlord or a tenant, to say, look, the lease says this, these are your rights, but I want you to go above and beyond to give them an opportunity to make this right. I want you to continue to communicate. I want you to, when you end up in court 6 months from now, I want you to show up to the judge and say, Judge, I've been trying to reach him for 6 months. I've sent 3,000 emails and 400 phone calls, and I haven't gotten a single response. The judge says, oh my gosh, that is crazy. So that's what you need to look like. You need to look like the victim, whether you're the landlord or the tenant. And as a final kind of question, Denise says, can you report on their credit that they failed to pay the rent? Tal probably knows that answer better than me, but I believe you probably can. I just don't know the process for it. I know that once you get a judgment, you can also garnish wages and things like that. And you might need the judgment before you can report on the credit, but you could always try. You could always try. So I hope that's helpful. Thank you so much for all the chat. As you see, I'm kind of looking over there. And then if you want to find more of these classes on my YouTube channel, you can just go on YouTube and search Christian Ross Evictions or Christian Ross Down and Dirty, and you'll find it. Unfortunately, if you just search Christian Ross, there's like 1,000 of me. In fact, I met a realtor the second time, I guess, Christian Ross. It was a beautiful Black lady that is a broker here in town. It was a lot of fun to do a closing for her. So I hope that you enjoyed this class. And if you don't have the handout, that you get it from Kendra, or you can reach out to me directly. And thank you again. I think you guys have something coming up in the next 15 minutes or so. So stay vigilant and good luck. And if you need me, go ahead and call me. Thanks, guys.